Thank you so much for being here in such great numbers. A true pleasure to see. Thank you in particular to Svenja Ahlhaus for joining us here in Amsterdam today. Svenja is Junior Professor of Political Theory at the University of Münster in Germany. Her research really spans broadly from theories of political representation in the ecological crisis to the boundaries of political communities, migration, citizen membership, and to questions of democracy and religion. Today, Svenja will be discussing the question of anti-democratic strategic litigation and its role in democracy, which is part of her recent and ongoing work. I think the paper this is based on, or rather the draft that this is based on, was circulated beforehand. And without much further ado, I would give the word to you for a presentation, and then afterwards, of course, we have time for questions.
Thank you for being here. Thank you for inviting me. Today I want to talk about anti-democratic strategic litigation. And this is part of a new research project that I'm currently starting. I've worked on strategic litigation before, mainly in the focusing on religious strategic litigation and a little bit on climate litigation, but here are many more experts in the room on climate litigation. So looking forward to learning something about that from you. And what I focus on is anti-democratic strategic litigation. So I'm a political theorist. I am not a legal scholar. I have a background in political science with a focus on normative political theory. And this is the perspective from which I'm going to argue today. And so you all know many different cases of climate litigation, and for example, the case, or the case in Peru, you have the Portuguese case, or many different cases also here in the Netherlands. And for a long time, we have discussed about climate litigation as a progressive tool for realizing democracy's promises. And today I want to focus on anti-democratic strategic litigation because I think that we should focus more on this dark side of strategic litigation that I will talk about more today. So when I talk about strategic litigation, I consider strategic litigation a specific form of legal mobilization. So for me, legal mobilization is the broader term. And here I use this definition, the use of law in an explicit, self-conscious way through the invocation of a formal institutional mechanism. And then there's one form of collective legal mobilization that is strategic litigation that I define as a practice of a collective going to court with a broader agenda of challenging or changing legal norms or the citizens' perspectives on these legal norms. And the question now is, what is the relationship between strategic litigation and democracy? And we have one story that is told about strategic litigation, and this is the progressive narrative. And the idea is that strategic litigation is a tool for realizing democracy's promises. And as any good story, it has heroes and it has everything that you need. What else do you need? A conflict, yes. And some kind of an arc that helps you understand why it's necessary that this hero, and in this case, the heroes are the agents, often marginalized groups, transnational advocacy groups, progressive social movements that use the law to protect their rights, to realize specific policy changes, and to hold decision makers accountable. And then turning to the effects, the story says, well, rights are working, slowly, but somehow it's working. So this is the progressive narrative that is told. This is also what many organizations that specialize in strategic litigation, for example, this one, identify here as their goal. So the idea is that strategic litigation is a tool to tackle injustice and to broaden political representation, to include voices that are not heard. But in recent years, we have a number of cases that don't really seem to fit this mold. So here we have cases, for example, the one here on the top corner, Lawyers for Trump, the idea that election litigation is used to undermine the results of a democratically legitimate election. And many of these cases were filed even before the result for the US presidential election was in. There are also conservative cases where specific rights of marginalized groups are rolled back. For example, the right to abortion. We have cases where we discuss some, for example, here, Christian groups behind the US effort to roll back LGBTQ rights. And there's this more recent discussion also in Europe about SLAPs, strategic litigation against public participation. And we have dedicated groups, international legal organizations specializing in a specific form of what some scholars call ultra-conservative or even right-wing legal mobilization. So this is the second story that is now told about strategic litigation and democracy, that it is a tool for undermining democracy's promises. And here again, we have agents, and the heroes are right-wing coalitions and ultra-conservative, often also religious agents, and they have different goals. They want to advance other interpretations of rights, want to challenge minority rights. So they're not against rights, to say, but against a specific understanding of rights, maybe. And turning to the effects here, research suggests that, well, rights are still working, and these often problematic goals are broadly, if slowly, achieved. And there's a discussion about how strategic litigation might lead to democratic backsliding, or whether they are connected to the erosion of democratic values. And so there are many recent articles, for example, by Southworth, by Kuchemba and Stambulski, Ozan, Escoffier, and others who have really focused on this debate about the right against rights, right-wing legal mobilization, or the idea of lawfare. And now, of course, the question is, what do we do with these two opposing stories? Can we really say that they are true at the same time, or what is actually going on with strategic litigation and democracy? So on the one hand, we have the progressive narrative, and on the other hand, we have this regressive narrative. And these are both stories that are told about the role of strategic litigation. So of course, one thing that we can draw from this is that strategic litigation is not neutral, we can say, but it might be used for different purposes. And this is not surprising at all, but how can we actually make sense of these two stories? So some scholars suggest that there is something like the positive story is over and now the negative story starts. So the whole backlash idea about strategic litigation now falling back into this regressive story. Other scholars suggest that this is more like a dual movement, a dual helix structure where these two stories are happening at the same time, and it depends on where you actually focus to see, well, it depends on your focus whether you will emphasize the progressive or the regressive story. Now, what I want to focus on is what is missing in these two narratives. And I think that these two stories paint too neat a picture. And the reality of strategic litigation, of course, is very messy. And these two stories are also intertwined. And what I find difficult is to actually see what are the perspectives from which these two stories are told. So who is the narrator of the progressive story and who is the one of the regressive story? Do we actually focus on agents? So does it matter whether a group is marginalized or not? Is it true that if you are a majority, you should not use the right to legal contestation? What is it a problem if hegemonic groups use the right to legal contestation? Is strategic litigation and its legitimacy dependent on the subject's position in a democracy? And I think this is not as easy as these two stories suggest, because hardly ever do agents, goals, and effects actually overlap. And it's not true that it's always good goals, good effects, bad effects, etc. And if we only focus on one specific policy issue, for example, here on climate protection, but also migrant rights, for example, or LGBTQ rights, it might be easier to see who is on which side and how they contribute to specific policy change. But if we want to look at many different policy areas at the same time, it seems more difficult to say that something is contributing to democracy or undermining democracy. So what I want to argue here is that from a democratic theory perspective, this progressive versus regressive or liberal versus conservative story, marginalized versus hegemonic, is insufficient, and we need more information and more normative work to actually distinguish democratic from anti-democratic types of strategic litigation. So this is what I focus on in this talk. Can we distinguish democratic from anti-democratic forms of strategic litigation? And so this means that we have to be more specific about the perspective from which we evaluate strategic litigation. And a lot of research, for example, in socio-legal studies, focuses on a specific movement and a litigation collective, and then asks, how does strategic litigation strengthen or weaken this specific movement and this political agenda? And there are many legal scholars who focus more on the court's perspective, asking, how does strategic litigation strengthen or weaken the separation of powers, for example, or the role of the judiciary? So whenever people write op-eds saying strategic litigation and misuses courts, then the perspective seems to be, is this good for the court? While others write articles, so should the climate movement focus on litigation? And here the focus is more on, is this good for our movement, for those who are aligned with these goals? And what I tried to do in my research is to focus more on a third perspective, that is the citizens' perspective. And citizens can be part of litigation collectives. Citizens can also be in the judiciary, but mainly citizens are participants in different forms of political participation. And the question then is, how does strategic litigation as one form of political participation strengthen or weaken political autonomy and equality? So this is the democratic theory perspective that I take here. Now, I have worked before on the democratic ambivalence of strategic litigation, and I think that strategic litigation can be both empowering and disempowering. But today in this paper, what I want to discuss is whether it makes sense to call some forms of strategic litigation anti-democratic. And the problem, of course, is that calling something anti-democratic is quite a thing. It's not just saying, ooh, this is problematic, but it's anti-democratic. It runs against democracy's core. And it is not something that we should use lightly. It doesn't make sense to call anything we don't like anti-democratic. But I want to argue that there is some use of the idea of anti-democratic strategic litigation that is justifiable. And the second problem is, well, how do we know that something is anti-democratic? Do we look at the intentions of specific agents? So going more in the direction of the goals and the agenda in the stories? Or do we look at the effects? So the consequences of specific forms of strategic litigation, for example, for the democratic process, but maybe also on the policy agendas. And this is a key distinction that everyone who's interested in how democracy is lost in recent years focuses on. So do we criticize people's agenda, or do we criticize what's actually happening then and their effects? So the question is, what is anti-democratic strategic litigation and how do we identify it? And my approach here is that I think that many of the problems that we face when we want to focus on how strategic litigation is used to undermine democracy is actually not new, but in the debate about democratic backsliding, democratic regression, democratic erosion, or autocratization, these are all terms that I use to indicate democracy's decline, and there are different notions and separate definitions, of course, but this whole literature in the recent years has been working on the question of how do we identify anti-democratic behavior, actions, and patterns before it is too late. So the idea is not that we say, oh, here are anti-democratic effects. They have already happened. And we as scholars say, now this was maybe not a good idea. But the idea is rather that we say, this is going to be anti-democratic. And this is why the distinction between intention and effect is important, because on the one hand, we want to say something before the effect has already happened. And on the other hand, everyone is a Democrat today. Even the most anti-democratic agents claim that they act in the name of democracy. So we cannot actually give much to the idea of stated intentions. So we can't work with effects and we can't work with intentions, apparently. So what do we do? And my goal is to provide conceptual, methodological, and normative tools for identifying anti-democratic strategic litigation. And this is the connection between the three literatures that I'm looking at. And in this paper, yes, there is an arrow. In this paper, I focus on the intersection between the democratic backsliding literature, mainly in political science, but also by legal scholars, and on strategic litigation. So, of course, the next question then would be, what can we do? But this is going to be part of another paper. I can come back. Okay, so anti-democratic strategic litigation. Here's my proposal. I have these 3 steps that I'm going through in the presentation. The first is that the use of an institution is anti-democratic if it undermines the democratic purpose of this institution. The second is the democratic purpose of the right to legal contestation is enabling citizens to scrutinize public and private power through formal legal channels. So this is how I understand the purpose of the right to legal contestation. And then putting 1 and 2 together here, anti-democratic strategic litigation involves a group's use of the right to legal contestation in a way that undermines the citizens' capacity for scrutinizing public and private power. So this is how an instrument, the right to legal contestation, that is designed for democratic control or scrutinizing private and public power is turned into an instrument for avoiding scrutiny. And I will explain each step in a bit more detail. So the first is, when is a political practice anti-democratic? And here I don't mean only strategic litigation, but more generally. The problem, as I mentioned before, is when should we actually call something anti-democratic and not just tricky? So here, anti-democratic is the term, and I argue that we can build on democratic theory approaches that distinguish between 2 interpretations of democratic institutions. And democratic institutions can be procedures, but also mechanisms. So on the one hand, we can look at the purpose of an institution that it was designed to fulfill. What are the aims that this specific institution achieves in a democratic system? But then we also look at what happens to a democratic system when this institution is used in the long run. So this is the mechanism effect. So we have to analyze institutions as procedures and as mechanisms. And so this means that for us, the question is not only, is the right to legal contestation anti-democratic, but rather, what uses of the right to legal contestation should count as anti-democratic? And here, my proposal is that we should call something anti-democratic if using an institution undermines the purpose of this institution. So in a way, if it's democratically self-defeating, we have the purpose of a democratic institution, and if using this institution in this way undermines this purpose, then we can call it anti-democratic and not just unjust or any other term. Which of course leads to the second question: what is the democratic purpose of the right to legal contestation? And this is, of course, highly contested, and many democratic theory scholars, legal scholars have worked on this. And so there are many different also methods of going about and presenting an argument about the democratic purpose. So we can have a genealogical argument. And so how does this come about? A more historical approach. And here I propose a reconstructive approach. So, and I follow a Habermasian strategy. If we want to find out what the purpose of a political practice is, we should look at it from the participant's perspective and ask, what are the assumptions that citizens have to make when they found these institutions, when they build these institutions? What are the criteria that they would set up for this institution to make sense in a larger democratic system? So we can build on Habermas between facts and norms here. And what's important is that we do not take the perspective of the court, we don't take the perspective of the social movement, we take the perspective of citizens and political participants. And here, what I argue is that the right to legal contestation has a contestatory purpose. So that's not a big surprise, probably. It's in the name. But the idea is that often the right to legal contestation has a defensive or a reactive role to play. So if something valuable, for example, an interest or a group or a right needs protection, this is why we have the right to legal contestation. So I do not try to argue that this is what's actually happening when people make constitutions. So it's not a factual argument about this is how the founders of a state reasoned. And I do not argue that this is what can be reconstructed from every empirical constitution in the world. But from a democratic standpoint, I argue that this can be considered the rational core of the right to legal contestations, the citizens' capacity to scrutinize power through formal legal channels. And I do not only mean public power, but also private power. So if we look at the idea of claiming your rights, it could also be claiming your rights against your neighbor, against a teacher, against a politician, against a policy. So the right to legal contestation is not just, so its rational core is not just supposed to be against public institutions, for example. But what is specific about it is that it uses, it scrutinizes power in a specific medium by going through legal channels. So if we just said the citizens' capacity to scrutinize power, then we could also argue that, well, the right to protest is exactly that. The right to protest, if we rationally reconstruct it, we can say, well, it's the right to scrutinize power and then to express your discontent with specific norms. And this is why I think that it's important to add this idea of through formal legal channels. It's a specific interpretation of scrutinizing power in a medium of law. And so we can scrutinize public and private power. As I said, it also includes companies or fellow citizens. So this is why I argue the democratic purpose of the right to legal contestation is enabling citizens to scrutinize power through formal legal channels. Now we come to the third step, where we combine these two ideas. So what anti-democratic means and what the purpose of strategic litigation is in a democracy. And so if we combine these two ideas, anti-democratic strategic litigation involves the use of the right to legal contestation in a way that undermines the citizens' capacity for scrutinizing power. And this is the idea of, so this is how, when I would use the term anti-democratic strategic litigation. So if we come back to the question of effects or agenda or goals, intentions. As I said, I think that many scholars of democratic backsliding face this problem. So how do we recognize the anti-democrat? And here I think that this helps us actually because we can look at how other people have solved this problem. And I want to argue that one way of challenging the idea that everyone is a Democrat and that of course, some aspects already seem legal and normalized. We can build on two methodological ideas. One is the foreseeable effects test by Petrov, and the other is Kim Schepele's method of forensic legal analysis. So Schepele wrote a short article that is quite famous because she argued against the idea of a checklist approach. So if you want to identify an autocrat or someone who is committed to democratic backsliding, she says, we cannot just have a checklist to see what they are doing, because if we have these separate items, we might miss the fact that they are interaction effects between different actions that are all legal and they all seem innocuous separately. But once they happen at the same time, the combined interaction effect is that this might undermine democracy. And so Schepele most often uses the example of Hungary. And so she calls this method forensic legal analysis. And she says, the idea is that we have to ask a series of what-if questions. So we don't just say what is happening, but we ask, okay, what if this new voter ID law is activated in a state where a certain minoritized group does not have regular access to IDs, for example. So we cannot just look at the legal proposal, but we have to have information about the context to actually evaluate the democratic nature of a specific proposal and their interaction effects. So if we use this idea and we combine it with Jan Petrov's idea of foreseeable effects, so Petrov looks at abusive constitutional borrowing. So this comes from the constitutional debate about, constitutional decline. And he says, well, we can't look at actual effects because that would be too late. We can't look at stated intentions because, well, people can state whatever they want today. So he argues that a foreseeable effects test is helpful in a way that it helps us we have to identify a normative benchmark. So we have to say, if this benchmark is met, then we have a problem, because then we can foresee certain problems. And of course, the foreseeing means that there is some level of speculation going on. We cannot just measure anti-democratic strategic litigation before it has happened. So we have to provide a plausible argument that certain effects are very likely. So, and this is why I think that democratic theory and empirical political science have to work together here to come up with plausible arguments about anti-democratic strategic litigation. If we combine these two ideas, so the what-if approach and the foreseeable effects test, we can come up with questions for identifying anti-democratic strategic litigation. So, for example, we can ask, what if this strategic lawsuit takes place in a context where there are deep economic inequalities and there's still very high legal fees, for example, or where access to court is highly dependent on specific, let's say, legal expertise, for example, or a background where a US president, a former president, has called the legitimacy of an election into question. So maybe just one lawsuit challenging the US presidential election is not an issue. But if we have hundreds of cases in a climate where a former president states that this is not a legitimate election, then we have a different context that we might want to consider. Okay, and now what I want to argue is that there's not just one type of anti-democratic strategic litigation, but I propose that there are three different ways. And the idea is that I ask, what do we need as citizens to scrutinize power? What are the preconditions for citizens to use our right to scrutinize power? And I think that we need active citizens, of course. We need democratic background structure, the democratic infrastructure, and we need an open public discourse. And the idea is now that there are three forms of anti-democratic strategic litigation because they target three building blocks of what democracies need for citizens to actually use their right to legal contestation. So to realize its purpose, that was scrutinizing public and private power. And so this is my conceptual proposal. I think that we can distinguish discouraging, damaging, and disempowering strategic litigation. And discouraging means that there are active citizens that are targeted. Here I connect this to the idea of slabs. Then there's damaging, where the target is core democratic rights, infrastructures, and institutions. And here I use the example of the lawyers for Trump. And then disempowering, which is one aspect that I've focused on in earlier research, where the target is public discourse. So whether citizens are actually able to build their own, make up their own minds about issues, or whether they are misled or distracted, or whether things are simulated for them. And this is what it looks like in a more pink version. Antidemocratic strategic litigation. So we have these three forms: discouraging, damaging, disempowering, and then these three targets. I was thinking about the question whether I think that they are exhaustive. So could there be a fourth version? And so I'm looking forward to your questions, but I think that for now, these to me seem the core building blocks of what scrutinizing power requires. So active individuals, infrastructures, and public discourse. But if we come up with an equally important idea or building block for what scrutinizing power requires, then I'm perfectly willing to add another word if it starts with a D. Okay, so here are the three kinds in more detail. The first is about strategic litigation as discouraging. And here the paradigm example that I have in mind are slabs. And I know that there's probably also here in the Netherlands a new discussion about slabs after the EU directive, where one of the member states have to come up with legislation to protect citizens against strategic lawsuits against political participation. And there's a renewed interest now politically because there are more and more cases also in Europe. And because now there is the critical lens has shifted to these cases. And the controversy is still ongoing, even in those cases where legislation has already been passed, because it's very difficult to identify slabs. It's not the fact that we can just say, oh, this is manifestly unfounded or this is abusive, but it's of course a matter of degree. Some states have clear criteria for when a state should be counted as a slab, but there's an enormous discussion that I don't think I can solve here. But if we take some examples, such as a local journalist in Germany who was threatened by a local politician and an activist who was threatened by the a German far-right party's youth organization because he tweeted something about racist and anti-Semitic speech at a meeting of this youth organization. And so the question is, here we have the idea of strategic litigation, a legal claim used to discourage an active citizen from using their right, in this case, criticizing racist and anti-Semitic speech. And so if we have a number of these cases where journalists, politicians, even academics, of course, NGO activists are attacked legally for using actually for speaking up, then we have this problem of undermining the citizens' capacity for scrutinizing public and private power. So if we want to do this more in depth, that I won't do here, what I think we have to do is come up with good what-if questions and then argue that if we have a number of cases, or if there is a pattern of local politicians or journalists being active, being attacked in this way. So we have to use this method of forensic legal analysis, these what-if questions, to then argue that it is plausible that we can have foreseeable anti-democratic effects. And we would actually have to do this for a number of cases to then create a background basis to say, oh, this case seems to be very similar to our to the cases that we've already collected. So there might be a high probability that this is another case just like this, where we can argue that it undermines the citizens' capacity for scrutinizing public and private power. The second then is damaging strategic litigation, and here we turn to lawsuits that target core democratic rights, infrastructures, and institutions. And this is the fact that I've already mentioned. So the lawyers for Trump, where we had hundreds of coordinated lawsuits before the 2020 presidential election. And researchers argue, for example, that they have been blurring fact and fiction. What is tricky for me in this case is that I wonder what we do with intentions here, because we can look at the effects, but of course if we say these are coordinated and orchestrated, then it very much sounds like a planned endeavor. And then I think the challenge would be that what is problematic here is not the anti-democratic foreseeable effect, but rather that they intentionally engaged in this. And so I still have this worry about what to do with intentions, and I will come back to this in a second. And then the third version is disempowering strategic litigation, and here I focus on those lawsuits where we can argue that they mislead public discourse by distracting citizen attention, by simulating public support for a specific issue, by distorting the institutional context. And here, one example is the Alliance Defending Freedom, one of the biggest conservative or right-wing legal organization that has been criticized for deploying the rhetoric of persecution to obfuscate the ADF's organized strategy of resistance against LGBTQ rights. So here the assumption is that they do not do what they claim they're doing, and they are hiding their agenda. So what I call agenda masking. Here, the problem is not the democratic agenda, but rather the fact that they use the legal instruments while hiding and masking their goals. And this limits the citizens' capacity for public scrutiny. So because the citizens are misled, they cannot use their right to scrutinize public and private power. And strategic litigation, because of its specific properties as a kind of political participation that activates citizens in a very special way, because most of us are not legal experts and only know about the narratives that the litigation collectives tell to the public about what they want to do, that there is this potential gap between what litigation collectives are doing and what they say they're doing. And this can be misused. And if this gap is misused, then we can say that they undermine the citizens' capacity for public scrutiny. Okay, so these are the three cases, and now I come to the end of the presentation. So what is anti-democratic strategic litigation? I argued that we should focus on this dark side of strategic litigation to understand how it is used and how it can be used. And I made three proposals: a normative one, defining anti-democratic strategic litigation as strategic litigation that undermines the citizens' capacity for scrutinizing public and private power. Then the conceptual proposal, distinguishing, discouraging, damaging, and disempowering forms. And the methodological proposal to combine the forensic legal analysis and the foreseeable effects test. So normalizing the use of what-if questions in evaluating whether something is anti-democratic. Now, as a last note, the question is, what do we do with intentions? I argue that we should always look for stated intentions, and we can also try to reconstruct the intentions and argue that they intended something anti-democratic, but this should not be part of the core definition of anti-democratic strategic litigation, but rather as an amplifier. So if we have information about an orchestrated attack or targeting of a specific infrastructure because we have, for example, leaked emails or a public report about a specific group, we can use this information to then amplify the urgency of challenging these forms of anti-democratic strategic litigation. But what makes it wrong is the problem that it undermines the capacity for scrutinizing public and private power, which focuses more on the anti-democratic effects. Thank you.